Well, welcome all of you to this Australian Academy of Law event, Freedom of Expression in the United Kingdom and Australia Considered Comparatively. The Australian Academy of Law is very pleased to host this event, chaired by Mr. Desmond Brown, CVE QC, on this very important topic. My name is Alan Robertson, President of the Australian Academy of Law, and I welcome all of you, as I've said, attending remotely, especially those of you in the early morning darkness in the United Kingdom. Soon, I hope, we'll be able to resume having these meetings in person, including in the UK. On behalf of the Academy, I acknowledge and pay my respects to the traditional custodians and owners of the lands on which we meet, and to their elders past, present and emerging. In particular, I pay my respects to the Gadigal people of the Eora Nation, the traditional owners of the land from which I'm speaking to you. First, a brief word about the Australian Academy of Law, and then I'll introduce Desmond Brown, who in turn will introduce tonight's speakers. So the Australian Academy of Law was established in 2007. It's an independent, permanent national body comprising some 400 fellows, including overseas fellows, of which Desmond Brown is one, distinguished lawyers from the judiciary, the academy, and the practicing profession. It's a not-for-profit, non-political organisation. And I'm getting some interference, so if people who aren't speaking could turn off their microphones, I think that would be a help. So this not-for-profit, non-political organisation that provides a forum for collaboration, constructive debate, and the effective interchange of views within the discipline of law. And I'd count this evening's event as a good example. And the Academy of Law was really established because there was no independent organisation that constituted a bridge between the members of the judiciary, the academy, and the practicing profession. Turning then to tonight's event Australian time, I'm very grateful to our speakers and panelists for agreeing to join this webinar at a busy time of year and at a difficult time of day. I'm also indebted to Desmond Brown for doing so much to devise and organise this event, but I note as well that the idea for an overseas event of this kind stemmed from a conversation between Desmond Brown and former Justice Bob Nicholson, AO, the first president of the Australian Academy of Law and resident in Perth. I mentioned Perth to illustrate the reach of the possible reach and the actual reach tonight of the people who are attending the webinar: Perth, Brisbane, Canberra, Sydney, Melbourne, and of course, I think in Desmond Brown's case, Sussex, and in other cases, London. It's my pleasure to introduce Desmond Brown, as I foreshadowed. He has a strong and long-standing connection to Australia. One of his great-grandfathers, he tells me, was the captain of a convict ship, and another great-grandfather was the second Chief Justice of Victoria, Sir William Stowell. Desmond Brown has practiced media law for half a century, specialising in defamation and privacy, and acting for both claimants and defendants. He's a former chairman of the Bar of England and Wales and treasurer of Gray's Inn, and he's coming to the end of 6 years as president of the 4 Inns of Court. He's the joint head of 5 RB chambers, which I think stands for Raymond Buildings Chambers. And a year ago, he received the CVE in the Queen's birthday honours in recognition of his services to diversity and the Inns of Court. So he's the ideal chair for tonight's event on freedom of expression. I now hand over to Desmond Brown. Thank you, Desmond.
Well, as many know, CBE is the acronym for Credit for Other Blighters Efforts. But welcome to you all. Introducing the four panelists, I'll start with Matt Collins. The Academy's flyer describes Matt as Vice President of the Australian Bar Association. So the first thing for me to do this evening is to congratulate him on becoming President. He's something of a glutton for punishment because until 2019, he was President of the Victorian Bar. Apart from his distinction as a practitioner, Matt has taught at both Monash and Melbourne universities, and in 2001 he published the first edition of his work on defamation and the internet, which for us practitioners is now regarded as the standard text. As though that wasn't enough, in 2014, 3 years after he took Silk, he brought out a new work, Collins on Defamation. Reports of his numerous appearances in defamation cases, but I suppose particularly that for Rebel Wilson, have reached these shores. And I noticed his appearance for the media in the contempt of court cases brought in relation to Cardinal Pell. But that's not the full extent of his practice. His briefs before Royal Commissions have been on behalf of clients as diverse as ANZ Bank and the Salvation Army. Laura Tingle, for her, journalism runs in her blood. The daughter of a distinguished journalist, last year she was elected president of the National Press Club in Canberra. Laura spent 16 years at the Australian Financial Review, latterly as political editor, before in 2018 joining the ABC, where she's now the chief political correspondent. Asking someone so familiar to viewers of the 7:30 current affairs shows to take part in a webinar at 6 p.m. was a risky course of Alan Robertson's, but I've learned that Laura's not on the screen tonight, but even so, I promise we'll try to finish by 7:29 p.m. Her references to Tony Abbott, which I picked up on the internet, show that freedom of expression in relation to political speech is alive and well in Australia, and I'm bound to say I'd not previously encountered the word clunkhead. Turning to Andrew Caldicott, Andrew is renowned in this jurisdiction as a media law specialist. His room in Chambers is a mere 2 doors away from mine, which is very convenient because he's the first person whose advice I would seek if I had a media law problem. He appeared for Naomi Campbell in her groundbreaking privacy case, and recently for the Mail in their unsuccessful tussle with the Duchess of Sussex. For many years, he's been in much demand for the BBC and for The Guardian, for whom he appeared at the Leveson inquiry into the behaviour of the British press. Our fourth panellist will certainly have the time to testify as to the value of Andrew's services. Somehow he's also found a moment to write a trilogy of novels dealing with a city-state hiding a cataclysmic secret. There are going to be no spoilers from me, but it has been praised by Hilary Mantel, no less, as a history, a tragedy, and a comedy all rolled into one. Our fourth panellist, Alan Rusbridger, joined The Guardian as a reporter in 1979. During his stint as a royal reporter, he visited Australia on the tour by the Prince and Princess of Wales, but I remember him first for his wonderfully sardonic reports on the Anglo-Australian comedy, which was the Spycatcher litigation. English witnesses may have been economical with the truth. Alan was certainly not economical with the irony. For 2 decades, from 1995, he edited The Guardian, breaking such public interest stories as the text of the diplomatic cables uncovered by WikiLeaks. also broke the Snowden disclosures in 2013 about mass surveillance. And he was the first to publish in The Guardian the phone stack hacking story, which led to jail for some News International journalists and also to the Leveson inquiry. Until this autumn, he was principal of Lady Margaret Hall at Oxford, a college, fortunately, with a Steinway Grand, on which he was noted for playing Chopin. Notable amongst his achievements was the innovation of a foundation year for students from underrepresented backgrounds, a scheme which I'm glad to say is now going to be rolled out across Oxbridge. He's now, once again, having left Lady Margaret Hall, editing the political monthly Prospect magazine, is now the chair he occupies, and he's also chair of the Reuters Institute for the Study of Journalism. The object of the discussion this evening is to discuss with concrete examples, if possible, the comparative position in our two jurisdictions in relation to both defamation and confidentiality and privacy, focusing on the extent to which they either protect or restrict investigative journalism. We're going to find that in relation to defamation legislation, the differences between England and Wales, I, for a moment, just stop to point out that Scotland and Northern Ireland are different, are not now as great as they were before the 1st of July this year, when the new model defamation provisions came into effect in New South Wales, Victoria, South Australia and Queensland. On one view, the legislative differences are perhaps today not so much in the substantive law, but the more draconian way in which, for some of us, it appears to be applied by the Australian courts. In the second part of our discussion, we'll look at how, under the influence of the European Convention on Human Rights, now part of our law by reason of the 1998 Human Rights Act, a law of privacy has come into being in England from pre-existing rights of confidentiality, which exist in both our jurisdictions. I'm going to ask now each of the four panelists to make short introductory statements. They've been asked not to spend more than 5 minutes each, but we'll start with Matt Collins. Matt, what protection does Australian law now afford to public interest stories, in particular under Section 29A?
Well, thank you, Desmond, and thank you for the warm introductions to all of us, and thank you for joining us tonight. I think there is cause for optimism for the media for the first time in a generation. Susan Jenkins might be able to just beam up a slide if that's possible. I'm going to show you a comparative analysis of the number of defamation cases which have emerged in Australia over the period from 2014 to 2018 when compared with the whole of the UK, including Scotland and Northern Ireland. So Susan, if you would press the first button. I had a researcher do an analysis for me of the number of references, substantive references to defamation law in interlocutory, trial and appellate decisions in the two countries. And that graph has been adjusted per capita. The orange part is Australia. We found 268 references in the UK for that 5-year period for a national population of about 66 million. In Australia, with our population of about 25 million, we found 577 corresponding references. And then if Susan would press the next button, I'll show you where they are concentrated in Australia. This graph shows New South Wales versus the rest of Australia. New South Wales is the orange part of the pi, 312 out of the 577 Australian references. And you can cut this any which way you like, I suppose, but if you assume New South Wales to be a jurisdiction and England to be a corresponding jurisdiction, that would imply about 10 times the number of cases per capita in Sydney than London. So we have got a problem, I think, although obviously it's a thriving jurisdiction for those of us who make a living out of it. And it's a problem which is somewhat confounding when it comes to public interest journalism, because on paper, we have had a defence which, for more than a generation now, which does not look all that far removed from the Reynolds defence that operates throughout the UK. And Susan, can I bring up the next slide? So since 2005, we've had section 30 of our model defamation provisions, which you can now see on the left-hand side of the screen. That provision was derived from section 22 of the 1974 New South Wales Act, so it's got a long pedigree in New South Wales, and it is a species of defence, a bit like the common law defence for the reasonable discussion of government and political matters that the High Court described in the Longy decision with which everyone will be familiar. But the defence which has been enforced for a generation is a simple one. There's a defence of qualified privilege if the defendant, the publisher, proves that the recipient has an interest or apparent interest in having information on a subject, the matter is published in the course of giving information on that subject, and here's the rub, C, the conduct of the publisher is reasonable in the circumstances. In principle, that defence ought to be effective to protect responsible public interest journalism. But in practice, I think it has to be accepted that it has failed, largely because of that adjectival qualifier, reasonableness, which has been interpreted very strictly in our courts. And just to give you some examples, which I think might surprise Desmond, Andrew and Alan, and no doubt depress Laura, that defence has never been allowed to go to trial in a case where the publisher wished to protect the identity of a confidential source. The rationale being that the reasonableness of the publisher's conduct cannot be assessed without giving the plaintiff the opportunity to challenge the integrity of the source. So a journalist who wants to protect a source has no entitlement in practice to rely on that defence. There's never been a successful defence of what the English would call reportage in Australia. Now, reportage is a species of journalism where the public interest in what is published or broadcast resides in the neutral reporting of an allegation and a counter-allegation, and where the public interest lies in the fact that the allegations were made rather than the truth of their contents. A concept very familiar to, no doubt, Desmond and Andrew and Alan, completely foreign to us in Australia, although in principle, Section 30 ought to allow for reportage defences. The Section 30 defence has never succeeded in a case where the plaintiff was not given an opportunity to respond to the imputations ultimately found to be conveyed by the trial court, as opposed to the imputations intended by the publisher, and even in circumstances where the publisher didn't appreciate the risk that the court might find different imputations to be conveyed. And the defence has even failed in cases where judges have taken the role of editor and thought that headlines could have been expressed in more temperate terms than they were by editors. I'm still a bit bitter about this, but in the Joe Hockey Treasurer for Sale case, in which I was for the defendants, the headline Treasurer for Sale got the publishers in trouble. In the judgment, the judge said it might have been better to have gone with the words Treasurer, donations and access. Now, from the 1st of July, we have if Susan would now press the button, the new Section 29A defence looks like this. It's a defence to the publication of defamatory matter if the defendant proves that the matter concerns an issue of public interest and B, the defendant reasonably believed the publication of the matter was in the public interest. It is modelled very closely on Section 4 of the 2013 Act that operates in England and Wales, which in turn is a codification of the Reynolds common law defence that's operated there for a generation or so. I am pessimistic about the prospects of the new defence because I fear that the use of the word reasonably in Section 29A subsection B will be interpreted as strictly as the word reasonable has been in Section 30. We don't seem to have judges with an appreciation for the professional judgments of journalists and editors of the kind that have led to the liberalised operation of the corresponding defences in England and Wales. But my 5 minutes is up. It would be churlish not to welcome the new defence because it consciously does copy liberalising developments, not only in England and Wales, but also in Canada and New Zealand. The extrinsic materials make it clear that it's intended to be a liberalising defence for public interest journalism, and it will no longer be possible for Australian judges, as they routinely have to date, to dismiss the Reynolds jurisprudence as being irrelevant in the Australian context for inconsistency with our constitutional traditions. So I think there is some cause for hope. Thanks, Jason.
Thank you. Well, I think the judges ought to be given a right of reply after what you've said. Andrew, can I ask you to tell us a bit about how Section 4 of our Act has worked in practice?
I think the first thing to be said about it, it is a model of brevity, which is rather refreshing. I think there's never been a problem with identifying matters of public interest, and I think generally there is agreement between the media and the courts. There are very few cases where there's been a dispute, a real dispute in this particular defence as to what is a matter of public interest. Much more interesting is the focus now on reasonable belief as distinct from responsible journalism, which was the way it was put in Reynolds. One aspect or consequence of that is that there is undoubtedly a renewed focus on the individual decision maker. And following Leveson, many judges also now expect to see something of an audit trail as to how the story came to be published. And one of the great problems in this field is that often privilege, in terms of the legal advice, is an absolutely central part of the story, but which any sensible newspaper wouldn't wish to share. But it does mean that there's a sort of slight artificial playwriting goes on, certainly in the non-tabloid media, in a really serious case, to try and make sure that there are documents showing proper editorial meetings and checking that the proper things have been done. What I did notice, and this did slightly concern me as a contrast between the Australian section and ours, we simply say that you take into account all the circumstances and there's nothing more specific. This follows really a concern that Lord Nichols's Reynolds criteria, which although he meant as a great pains to say they were non-exhaustive, came to be used as a sort of anorak checklist. And if you dropped a couple of marks, you were liable to lose the defence. And that caused considerable unease. There was a very important case called Flood and Times newspapers, where the House of Lords, as it then was, said that there are even cases where it's not necessary to verify, even though it is not a reportage case. And that was where there was a certain formality to the leaked document, which made it sufficient to operate on the basis of that alone. Reportage we keep, and as Matt eloquently put it, the downside is impartial. The upside is you're relieved of any obligation to verify. It's particularly valuable here in the give and take of political discourse, the kind of slanging matches that go on. And provided there's a degree of in the blue corner and in the red corner, you should have a run. And I think it has stopped some actions. Editorial judgment is to be given specific weight. I have to say that I've always been concerned about the complexities of judicial decisions under Reynolds. If you read Flood, it's an extremely complex and long judgment. Whereas in Campbell, years ago, Lord Hoffman said the practical exigencies of journalism demand that some latitude must be given. Editorial decisions have to be made quickly with less information than is available to a court, which afterwards reviews the matter at leisure. That has not always been my experience that is truly honoured. I just wanted to mention just two other matters before I use up my time. One is the problem that Matt alluded to about the meaning which the journalist intends his piece to convey, and the extent to which you can rely on the reasonable range of meanings and pick one. That is not referred to expressly in section 4, but I think it is still part of the thinking within all the circumstances of the case. But I can see it may be argued that this principle has now gone, because it's a little hard to read it as just a circumstance of the case. It's actually a sort of rule of law. The only other point that I would briefly make is about confidential sources, which are so important. I think my experience is that the English courts are very respectful of the importance of confidential sources. They tend not to order their disclosure, but they are suspicious of them, and I think very aware of the Bernstein-Woodward approach, that you use a confidential source to tell you where to go, but not as your only and primary source. That's not a rule of law, but I think it is sometimes privately what judges think. That, I think, is at least my 5 minutes.
Thank you very much. Laura, turning to Australia now, what practical difficulties do Australian journalists currently confront in getting legitimate public interest stories published? Your mic is off, I'm afraid.
No, I'm right. Sorry. You know, I work in television, so my technological skills are fabulous. Look, I'm obviously not a lawyer, but it's fascinating listening to the sort of British experience here in terms of things like judges who actually understand journalism and English courts being respectful of confidential sources. I suppose what I would like to just highlight in my opening remarks doesn't go to the practicalities of specific sections of the defamation regime. It's more about what I'd see as the biggest threats to investigative journalism at the moment, which actually go to the creeping reach of our national security establishment, and it's obvious, it's sometimes often absurd definitions of what can be kept secret in the national security interest. And there's been a lot of law that passed since sort of 2001 to sort of back that. It's all sort of slightly paranoid, and it shows the increasing reach and influence of the national security establishment within the government and within the parliament, I would argue. It's not just about matters of national security, though. It goes to the mindset that's spread to the general reporting of government at its most trivial, and put up shutters around what would in the past have been accepted standards of accountability. We've got high-profile police raids on media offices and journalists' homes, and it's partly why we've had a press freedom inquiry being conducted by the Joint Intelligence and Security Committee of the Parliament. So I suppose my sort of opening gambit would be to say, look, it's given this great boldness to our federal politicians, particularly in the way they can run some utterly conflicting arguments about the right to free speech at the one time, and also do completely contradictory things in the realm of defamation. For example, Defence Minister Peter Dutton has recently won a legal case claiming he'd been defamed on Twitter. Earlier this year, the former Attorney General, Christian Porter, sued the national broadcaster, which employs me, over stories he alleged defamed him, claiming an article which did not name him made false allegations against him. Now, where it sort of falls into the sort of area of defamation, I think, is that it emerged Mr. Porter's legal bills, and where defamation laws go in particular is Mr. Porter's legal bills turned out to be funded from a anonymous $1 million legal defence fund, but the government backed Mr. Porter's refusal to disclose who the donors to that fund were, despite that being clearly in breach of ministerial and even parliamentary standards of disclosure, partly because the argument was that taxpayers should be funding the defamation actions of ministers and MPs. Now, while they were doing that, at the same time, they're announcing just in the last week or so proposed changes that would make social media platforms legally liable for defamatory statements by anonymous trolls. Now that sounds great in theory, but it overlooks the fact that not all that many people can actually afford to take defamation proceedings. But of course, if suddenly the taxpayers of Australia were having to pay for government ministers to be able to sue for defamation, that would significantly increase the pool. So I suppose, and at the same time, the Prime Minister and other senior ministers are defending the rights of their rebel backbenchers to put out kooky stuff about COVID and all sorts of conspiracy theories in the interests of free speech. I'll just very quickly list a couple of cases of note in this. The long battles that have been waged in the courts about allegations of war crimes by Australians soldiers in Afghanistan, and particularly the extraordinary case of witness K and his lawyer Bernard Collaery. For those not familiar with that, it involves a whistleblower known as witness K, who revealed that Australia had been bugging meeting rooms in the offices of the Prime Minister of Timor-Leste at the time Australia and Timor-Leste were negotiating over gas rights in the waters between the two countries. Now, witness K has been tried and served a jail sentence, yet we're still not allowed to name him or say exactly what he was convicted of. And when Christian Porter was still Attorney General, he used the national security powers to ensure the trial of his lawyer, Bernard Collaery, would be heard in secret with a complete lack of public scrutiny. That's going to be very interesting, I think, in this broader realm of what constitutes national security, freedom of expression, and the right to know, because I think it's going to go all the way to the High Court. So there are a few starting points. To me, as a working journalist, it's the combination of these national security laws, the defamation laws, and the Evidence Act, and the fact that we can't often use documents obtained as leaks in a defamation defence because of the Evidence Act, and that was a particular problem with the so-called Pandora Papers, which of course were published globally a short while ago.
Thank you, Laura, and thank you for reminding us that we're not simply concerned with the restraints on journalists provided by the law of defamation. I mean, as I understand it, in Australia, the Attorney General has wide-ranging warrantary powers to get even behind journalistic sources, doesn't he?
He does indeed, and those powers just keep being extended. So, it's become, quite an oppressive environment in which to be trying to write stories in that sort of realm.
Alan, with the reforms that we've had in England, how great are the obstacles which still confront English journalists in getting stories of legitimate public interest published?
Well, nobody's mentioned money yet, and money is the crucial thing, I think, in a world in which so many aspects of the media are now on their knees for reasons we needn't rehearse. I remember giving evidence to Parliament about 10 years ago, and there was a local newspaper editor there who said if they got a legal letter, they immediately settled. I mean, they put up the white flag because they had no money, they had no legal budget. And of course, word of that spreads, and people know that newspapers will fold if you write them a letter. Yeah, I think one needs to be realistic about the fact that it's all right for the big media beasts, just about still to fight cases, but especially at local newspaper level, there's a terrible problem that newspapers can so easily be silenced. We've Andrew knows that we've been grateful for his services in some cases, but we've had to risk, when on the Guardian, £500,000, £1 million to fight cases that were arguably in the public interest, but how many news organisations are able or willing to do that nowadays? I think that the truth is my impression is that libel, the modest reforms that have been made to libel over the years have helped a bit in recognizing public interest journalism, and although we too in the UK have stubbed our toes on the kinds of things that seem to be bedeviling Australian publishers, I think the attention has now switched to aspects of data protection. There's something called the misuse of private information, which is now creeping up on the inside track, and of course privacy. I think, as in the past with libel, if newspapers simply can't afford to publish these cases, no matter the public interest, you have got a situation where London is still being treated as the libel capital of the world, and the privacy capital of the world by people who've got the money to spend. And it would be nice to report that the public interest was the shield that we hoped for. But I think that is not proving to be the case. I'm glad that Laura mentioned national security. There's a threatened bill that would really make the kind of reporting that we did of Snowden impossible. It gives journalists no public interest defense. It doubles the time that an editor might spend in jail for doing the sort of things that I did over Snowden. And it allows the government to define what the public interest is, which anybody who's followed cases like the Pentagon Papers case will know that that's a nonsense. The problem is that the notion of the public interest is such a difficult and slippery one, and really different types of newspapers define it in a different way. Saving Andrew's blushes, I think what Meghan Markle did or didn't write to her father in 2018 could barely matter less. It has no impact on the lives of 68 million Brits, but it does sell copies, and this is where it intersects with the cost bit. Of course, newspapers have to sell copies, and there's no doubt that an obsession with Meghan Markle has helped the Mail website in particular to become the biggest newspaper website in the world. And if you sell copies and you make money, then you can do good journalism as well as terrible journalism. And I think this is all now getting very murky. Those of you who followed the Leveson inquiry 9 years ago saw the learned judge's attempt to shine some light on the relations between press and the politicians. But in yesterday's Times, we read that a struggling government is offering a little morsel to the press and saying, well, how about if we slip something into the legislation that would order the courts to prioritize freedom of expression over privacy? Now, that seems to me a terribly Faustian deal, because intrusion into privacy is a great business model. That's the cost bit. And if we've got a government that is going to weaken privacy, the protection of individuals, and if that's going to return to the bad old days of phone hacking, not necessarily the techniques, but the results, I'm not sure that's a great model of public interest journalism. But you've got this government, I think, trying to curry favor with the press in this way, at the same time as attacking a model of journalism, the BBC, which is one of the most trusted on the planet. So I think it's all a bit of a mess. If what we're aiming for in a world of growing information chaos is trusted, responsible public interest journalism, we're not doing very well to protect that. And at the same time, I would rather fear for returning to the days of gross intrusions of privacy, which thankfully have lessened over the last 10 years. And so I wish I could come to you with a more cheerful story from my point of view, but I think there's quite a lot to worry about.
Well, I noticed yesterday's Times as well, with someone from Number 10 quoted as complaining that the approach was much more Germanic since the Human Rights Act.
These damn continentals, yeah.
Let's now look in a bit more detail at the 2013 Act, and in particular, something we haven't touched on, which is Section 1, the section which makes it a statutory precondition of serious harm to reputation. Andrew, in your experience, has that wrought a great change? I mean, I would certainly answer that question, yes.
I think one of the problems is it does throw out the truly trivial, and that is a benefit. I mean, Alan and I occasionally wrestle with really rich, vain people suing on the most trivial things with very expensive solicitors, and it just squeezing through. So that is a benefit. One of the problems is that in more borderline cases, the question of serious harm with an individual tends to go to trial. So on the point about money, you have to go down the whole track to deal the lethal blow. With companies, however, I've got 2 cases at the moment where we've got hearings before defence to try to get rid of cases brought by companies. And I think they are struggling. And personally, I think it's thoroughly beneficial, because a lot of these corporate claims are actually not really brought for truly vindicating reasons. I think it's companies. I think it's a real value, and individuals in the truly trivial cases. But the fact it goes through to trial in the more borderline cases, as I say, is rather less helpful.
Just for the Australian audience, that Section 1(2) of the Act provides that a company has to show serious financial loss,
Or at least yeah.
Or the likelihood of that. At what stage is that issue determined by the court?
The court seemed quite willing to engage with evidence as to whether there is a likelihood of serious financial harm as a discrete early hearing. I know of at least 2 such orders already in the pipeline, because they say it's a threshold requirement, and there's not much point having threshold requirements if you have to go all the way through to trial to resolve them.
Matt, under Section 9 of the Australian legislation, what corporations have a cause of action for defamation?
Very few is the answer. So this dates back to a New South Wales reform at about the turn of the century, which was then extended nationally with our model provisions that came into force at the start of 2006. And the result of it was that almost all corporations lost their right to sue for defamation. There are exceptions, and the exceptions are broadly not-for-profit companies, so charities and the like, and small businesses. And a small business is defined quite arbitrarily as a company with 10 or fewer full-time or equivalent employees at the time of publication. The rationale for the reform was never particularly clear. It may have been motivated by a spate of SLAP suits, strategic lawsuits against public participation, in the 1990s, where property developers were seeking to silence community opposition to controversial development processes by issuing defamation writs. But it was certainly a boon for the sort of tabloid current affairs programs, not the sorts of ones that Laura appears on, but the ones where the camera chases the shonky car dealer down the street. There's certainly more freedom for those kinds of exposés. But we now have, though, adopted from the 1st of July the position as in Section 1 of the English Act, in Section 10A of our Act. And so although most corporations have already lost their right to sue for defamation, those that have retained the right to sue for defamation must now also prove, as in England, that they've suffered or are likely to suffer serious financial harm. The effect of it, though, has been to revive alternative courses of action, because if you're a corporation whose reputation has been harmed by a publication or a broadcast and you've lost your right to sue for defamation, you look for alternatives. The alternative in the Australian context has been the revival of the old 19th century tort of injurious or malicious falsehood and other sort of exotic causes of action, for example, under our competition law.
Malicious falsehood requires the claimant to discharge the burden of proof on both falsity and malice. So that's why it's never been very attractive here.
Yeah, you would never plead it as an alternative to defamation law, because the plaintiff gives up the inherent presumptions that favour the plaintiff in a defamation action. It's not just, in a malicious falsehood claim, the plaintiff must prove falsity, whereas that's presumed in defamation law, must prove malice, which is only relevant in defamation law if certain defences are relied upon, and must prove actual financial loss, whereas loss is presumed in defamation law. So yes, it's a much higher burden.
Laura, in the aftermath of the Geoffrey Rush case, which is now a little time ago, where a judge awarded $850,000 by way of damages, the Guardian said that Australia's defamation laws were notoriously complicated and strict. In your view, is that still the case? Do you get the impression that journalists have it easier in England?
Well, I think just purely based on what we've been talking about today, that would seem to be the case. I mean, just the general sort of culture of, there's two things. One of them is we don't have that sort of culture to the same extent of stories of the sort of Meghan Markle type that sort of go into people's characters, particularly go into sort of to issues of their private lives, which is partly why I think the Geoffrey Rush case was so interesting, because it was this high-profile figure, and his behaviour, was put under intense scrutiny, which is actually, I think, Matt might correct me on this, but I think in general it's just not anywhere near on the same scale in the sort of broad sweep of what Australian media does. So that's a difference. But certainly I think, in terms of, all the various defences that we have, the fact that, there's not that sort of idea of reportage, all of those things do definitely suggest that that journalists do have it easier in England and Wales, just, culturally, in terms of the view of judges.
There have been several mentions of the Meghan Markle case, and Alan pointed out that Andrew was counsel for the Mail. So there are obviously professional limits to what you can say, Andrew. But just looking at it more broadly, was there anything unorthodox about the manner in which the Court of Appeal approached the law in the Meghan Markle case?
My own view is that there were three kinds of public interest engaged in the Markle case. The first was what you might call corrective, because the allegations against Markle in the People magazine were to some extent demonstrably untrue. Secondly, his right of reply, which traditionally is wider than the corrective principle, because he'd been attacked and therefore was entitled to give his defense. And in the law of defamation, it's quite generous. And the third is the wider public interest. And you may think that talking about the wider public interest, in this context is difficult, but I think there is some public interest in understanding why he didn't go to the wedding and whether the account that had been given was a true one, and the reason for the breakdown in the relationship with her father. The court took a very strict view of the corrective principle and allowed only one sentence to be used from the letter. It was portrayed as a loving letter in the People article, and part of our argument was that he was entitled to show in reply that it certainly wasn't a loving letter, and you needed rather more than one line to convey that impression. And the other argument was that the People magazine was based on what her friends had said, but it was clear that one of the main false allegations had been made by her herself in the letter. And we pointed out that was something we should be entitled to say. So I would say, although one could see that there are quite a lot of arguments about how much of the letter the Mail used, I still think it's a pretty restrictive decision. But there's very little law in it. It's actually, there's very little exploration of the facts, and they end by saying this is a very narrow decision. But that's, I feel, as much as I can say at the moment about it.
Alan, you've said that the letter that Meghan had penned to her father couldn't have mattered less, but the Times suggested that the decision had moved the goalposts in relation to the law of privacy. Is that how you see it?
Well, Andrew and I have been through many cycles of these kinds of complaints. I mean, the Times is owned by Rupert Murdoch. Rupert Murdoch owns The Sun. And in these kinds of cases, you tend to get a sort of class action, as it were, by the publishers of tabloid newspapers, who, of course, want the liberty to be able to intrude into privacy. That's their business model. And the high water mark of that was the phone hacking revelations and the Leveson inquiry. And personally, I feel things have calmed down a bit on the privacy front, and we don't wake up to see people's lives being ruined every Sunday morning in the way that used to happen with the News of the World. So I think it's a reasonable balance that is being struck if you're not a tabloid. If you're a tabloid, of course, you want the liberty to be able to go back to the bad old days. I perfectly understand why they argue that and why the Times should join their tabloid sistermate in arguing that. But I worry about any Faustian bargain between a government that wants the press on their side and newspapers in whose interest it might be to form a temporary truce with the government in order to get the kind of legislation that would help them do that kind of reporting.
Matt, I want to turn now to interlocutory injunctions. In Australia, you have a rule like we have in this country, going back to Victorian times, that the court won't grant an interlocutory injunction in defamation if the publisher asserts that the story can be justified as true. As I understand that rule in Australia, it's pretty inflexible. But are there ways round the rule by invoking a different course of action? I'm thinking particularly of the attempt in the Dr. Lanza case.
Yes, well, in defamation law, you're quite right. We've adhered pretty strongly to the old principle in Bonnard and Perryman, the English case, which I think dates back to the late 19th century. It's a bit of a paradox, because while our defamation laws are very plaintiff-friendly, it is very difficult for a plaintiff to get an interlocutory injunction other than a very clear case. So we just don't see very many interlocutory injunction cases in the defamation field. And our High Court's last pronouncement on the matter was in 2006 in a case called ABC and O'Neill. Incredibly complicated judgment. There are 4 separate judgments and 2 dissents. And the key to it lies in a terrific paragraph, an uncharacteristically acerbic statement by a judge of our High Court, Justice Hayden, who said, there is no majority in the court on any contested point of law. In truth, only one proposition of any importance flows from it. That is that, as a practical matter, no plaintiff is ever likely to succeed in an application against a mass media defendant for an interlocutory injunction to restrain publication of defamatory material on a matter of public interest, however strong that plaintiff's case, however feeble the defences, and however damaging the defamation. So to come to your question, that's right. In order to seek an interlocutory injunction, a plaintiff must steer away from defamation law and seek to apply the ordinary principles for the obtaining of an injunction in respect of other causes of action. You raised Lanza. Lanza was the cosmetic surgeon who was the subject of an expose on the ABC's Four Corners a few weeks ago. I represented the ABC in that case. The plaintiff failed in his injunction application, but it was interesting because he sought to invoke a breach of confidence, a breach of employee duty provisions in our corporations legislation, and other exotic causes of action, steering entirely away from questions of defamation.
Andrew, sometimes people have relied on non-disclosure agreements as the basis for an injunction to restrain defamatory allegations. And that was the case very much so with Sir Philip Green and his company. They obtained an injunction against the publication of allegations of sexual harassment. But what was the approach that the Court of Appeal took in that case?
I mean, I think it's what really underlies that case is the enormous emphasis on achieving settlements. Our new civil procedure rules have an enormous emphasis on mediation and the benefits of early settlement. And non-disclosure agreements, despite understandable concern, and there's, I think, little doubt that they are misused quite frequently by quite powerful corporations to suppress true complaints. The courts are very, very concerned about the consequences of unstitching settlement agreements, particularly where complainants have accepted really quite substantial sums in consideration of giving up their right to complain other than to the police or to an appropriate investigator. I think it's clear that an NDA would not be enforced if it sought to prevent the person from going to the police. But there was an earlier case, in fact, of mine when I was acting for a defendant called Myonis, which was quite influential on the result. And that was where, bizarrely, some Greek publishers had virtually agreed in the settlement agreement really not to refer to the plaintiffs by name ever again. It was a completely lunatic thing to have agreed. But the court said that's what you agreed, and we're not going to allow you to wriggle out of it. So it's really the value to the overall system of compromise, which I think underlines those decisions. But there are deep and really quite difficult contests of policy lying underneath, which are difficult to resolve in particular cases, I think.
Laura, even in a case of alleged serious sexual harassment, would the media accept that there is a public interest in enforcing non-disclosure agreements for the reason that Andrew has given? I mean, I seem to recall in one of the cases, one of the women who was the subject of Philip Green's litigation had received as much as £1 million in compensation. Should money seal people's lips?
I would sort of argue not, but I think from a journalistic perspective, NDAs are really problematic. I mean, sometimes they can't really be enforced in practice because, you know, other forms of information can render them at least partially not workable. And also there's the question of NDAs that have been or could be perceived to be signed under duress. And then you've got this whole raft of NDAs that have come up, you know, in our Royal Commission into institutional child sexual abuse, where some institutions got a whole lot of people to sign NDAs who were really very vulnerable and should never have been put in that position. So I think they are very, very problematic, both in terms of not protecting people and certainly not protecting the public interest. I don't know if that quite answers the question, but I think they're really, really, they're not an answer that really works for anybody, I would have thought.
We have half an hour to go, and I want to turn now and focus a bit more on privacy. Matt, answer yes or no. Is there a law of privacy in Australia?
If I'm restricted to one word, the answer is no.
Right. And we, in this jurisdiction, we all think of those poor possums in the Lena Game Meats case. Have things moved on since then?
Not much, no. So it gives another paradox in that we have these very plaintiff-friendly defamation laws, but we have no protection for privacy. But I also think law is right to point to a cultural difference between the Australian media and that of particularly the Fleet Street tabloids. We don't have the same tradition of waking up to the red mastheads ruining people's lives, and it is unusual for something like the Geoffrey Rush case to break through. I mean, ABC and Lena Game Meats is the high point for the common law in Australia, with a High Court saying that if the right case came along, there might be a cause for developing a tortious cause of action for invasion of privacy. But our courts have tended to be very timid when it comes to the evolution of common law principles, and we don't have the same spurs to evolution of principle that you have through your Human Rights Act and the domestic implementation of the European Convention on Human Rights. Intermediate courts in Australia have from time to time recognised causes of action for privacy, but they've never broken through at the superior court level. And our Law Reform Commission, actually, when it was led by Michael Kirby back in 1975, recommended the adoption of statutory causes of action for privacy. And so I was looking at it today. Michael said in that if you left it to the common law, it would take generations to develop. Well, that was prescient. And in 2008, the Law Reform Commission again recommended the enactment of a statutory cause of action for privacy. But I think the media has been implacably opposed to that course, and no government has dared to take the media on over it.
Well, it may be another generation that develops it. And I'm thinking that Lena Game Meats was Chief Justice Gleeson. Perhaps his daughter in the High Court will now do something to carry the standard a bit further.
It needs the thing about the common law is you need the right case to come along. You need a case that really does pique the interest of the court and encourage the development of the principles. There was a case at the Victorian Court of Appeal that came pretty close, which was a dissemination of a sex tape by a disgruntled former partner of the plaintiff. But there the court just shoehorned a remedy into breach of the old cause of action for breach of confidence and eschewed the need to go further. Yeah, but you're right. There's always another case.
The boundary between confidentiality and privacy is an interesting one, and perhaps it's exemplified by the controversial decision in an anonymised case, PJS, in the Supreme Court in 2016, whereby a majority of 4-1, the court restrained the publication of information about sexual behaviour, even though it was in the public domain and available over the World Wide Web. Andrew, what was the court's justification for that? And that was stuff which was firmly and squarely in the public domain, and yet it was restrained as an infringement of privacy. Now we've lost Andrew. I hope that's just temporary. The basis seems to have been fundamentally, to answer my own question, that you could still have an intrusion into private life, even though the material was in the public domain. And indeed, insofar as there was repetition of the intrusion on privacy, that made it worse rather than extinguishing the cause of action. I mean, Matt, is what would have happened on those facts in Australia? It would have been a non-starter, wouldn't it?
A non-starter. I can think of an analogy in the Australian context that most of the Australians will be familiar with. Dean Laidley was a very well-known Aussie rules football player and coach, sort of a god in Melbourne. And out of the public eye, Dean transitioned and has lived for some time as a woman, Danny. Last year, she was arrested and taken to be questioned by police, and some police officers surreptitiously took photos of her in an incredibly distressed and vulnerable, sort of humiliating state. The photos were leaked to the tabloids and duly plastered all over the front pages of the papers. It was such an extreme example that searches on Danny Laidley's name were the #1 Google search in all of Australia last year. Now, the police officers are in trouble. They've been charged and are presently before the courts. And Danny Laidley has a case against the state of Victoria on the basis that it's vicariously liable for the conduct of the police. But there's no cause of action against the tabloids, who, of course, did the proximate damage to Danny's life and reputation.
Yes. Let's think about a more recent case, one in fact which reached the Supreme Court last week, the case of ZXC and Bloomberg. I mean, that was a case where the Court of Appeal confirmed an injunction granted in relation to the confidential contents of a letter of request by a UK law enforcement agency to a foreign state concerning the claimant who was suspected of criminal offences. Now, the court applied the same reasoning as in the notorious case of Cliff Richard against the BBC. Alan, do you have any sympathy for Sir Cliff in the way in which the BBC treated him?
I do. I think the BBC, that's a case that the BBC would have been well advised not to fight through, because it's another example, I think, of when the courts get inside the behaviour of newsrooms. It's not always to the advantage of the newsroom. So the court was able to get in and see lots of the memos that have been flying around, which were couched in terms of journalistic excitement and didn't read so well 18 months later in the court. And the BBC, I think, went over the top in hiring helicopters and so forth to witness the raid by the police on Cliff Richards, and it's not surprising that the BBC lost that. From what I know of ZXC and Bloomberg, it's an entirely different kind of case about whether it is reasonable to put into the public domain the fact that somebody has been arrested or is being interviewed by the police. And from what I know of the case, it's a completely different argument. This is a businessman who we're not allowed to know who it is. And it seems to me the public interest in knowing that a business person has been arrested is completely different from the raid on Cliff Richards. So I think a lot of journalists are very hopeful that in the ZXC case, the Supreme Court will come to a different verdict, again based on the public interest of the information, which I would have thought was high.
Andrew, in the light of that, we've all watched parts of the oral argument streamed live from the Supreme Court. Is it foolish to hazard a guess about Bloomberg's chances of success?
Yes, I'm afraid I don't share Alan's optimism, having watched quite a lot of the argument. I mean, the really peculiar thing about that case is that they didn't run confidence, and this was a confidential letter, and they would have thought there was a very straightforward claim in confidentiality. I certainly agree with Alan that it's troubling that businessmen or politicians or people of that sort can be said to have a reasonable expectation of privacy, and the fact that they're being investigated by the police. And I also fear that if the Supreme Court find that there is a reasonable expectation of privacy, it's going to skew the balance when you get to the second phase, which is when it's weighed against the public interest. my own view is that people are losing sight of the fact as to what truly is private. And there's obviously a difference between the ordinary person and someone who is, acting, raiding pension funds or acting on behalf of a public company or in politics. And it does seem to me that it's really crucial that the Supreme Court engage with that distinction. But I have to say the signs were not that encouraging if you were watching the questions from the court.
That was my impression too. If anyone wants to put money on it.
I mean, the only other thing to say is that they seem to be very attracted by the argument that anything which potentially impacts on your interaction with your fellow men, including your esteem, may be enough to engage Article 8's privacy rights, irrespective of how public-facing your responsibilities are.
Well, that is very much influenced by the Strasbourg case law, isn't it?
Yes, although there is a line of Strasbourg case law which says that if by your own conduct you attract investigation or you commit crimes, you can have no reasonable expectation of privacy. And there was a rather stony silence when that line of authority was cited.
Matt, I want to turn now to the right to be forgotten and ask you and Laura about that. In the Luxembourg court, in the well-known Google Spain case, it was held that there was a right to be forgotten. And you probably know of the English case in which the court made Google remove reference to a spent conviction of a rehabilitated claimant. There's none of that in Australia to date, is there?
No right to be forgotten, no right to have matters removed from archives.
Yes. Laura, would you have any sympathy for a rehabilitated claimant? I don't know in Australia whether you have rules whereby convictions become spent after a particular period of years.
I actually do, and I actually had a particular incident where I had written up a story, and I can't even remember the details now, and it involved somebody who I think was a junior political staffer, as they say, was cannon fodder in whatever the story was, which was about a bigger issue. And he contacted me about 10 years after the story appeared and said, look, when people Google me, they keep coming up with this story and it's basically ruining my life. And, is there any way you can, remove the story from, I think it might have been on my own website, which is somewhat defunct these days. And I did think I tried to assist him in that because he wasn't central to the story. It was one of those things where he'd been named because he'd been carrying the envelope or something that day. It was just one of those chains of events. And so I think people do have a right to be forgotten. Can I just say something about the expectation of privacy issue, if that's okay? Have we got a couple of minutes just to do that?
Yes, we have.
Look, this doesn't actually go to anything before the courts at the moment, but I think we've got a couple of really interesting things happening in Australia at the moment in that regard. One of them is in relation to the former Premier of New South Wales, Gladys Berejiklian, who's up before the anti-corruption body in New South Wales over her involvement. She chose a rather dodgy boyfriend, unfortunately, but there are questions about whether she sort of facilitated or knew about what he was doing. He was another MP. And there's been a lot of, because she was a very popular Premier, there's been a lot of outrage about the fact that the personal side of that relationship was put on display, that there was a public playing of, intercepted conversations and things. And the Prime Minister, as we speak, is sort of using this to try to, which is quite ironic since apparently they don't like each other, to sort of facilitate her getting pre-selection into a federal parliamentary seat, which they want to win. I think it's just a really interesting and rare case where private lives of politicians are out there, and it's sort of being argued in fairly irrational fashion. On a completely different front, there's a very terrible story that's been going on for some years about a little boy who was wearing a Spider-Man suit and just disappeared from his foster grandmother's garden one day, and they've never found him. And the police have really used an exposure of naming people's of interest in the case repeatedly to try to sort of pressure various persons of interest into fessing up. And they've got a current sort of strategy of doing that with the little boy's foster mother at the moment. And I think, one, that's horrendous. And I think in both the Berejiklian case and in this case involving this particular episode, it'll be interesting to see whether there are ever any attempts, I suspect not in the Berejiklian case, but in whether there will ever be an attempt to basically sue over the way those people have been treated by the police, as a investigatory tactic.
Well, Miss Berejiklian may get her vindication from the voters of a federal constituency, I see reading the papers.
So I'm still not sure that she's actually going to run. I think it would be highly hazardous, but that'll be one of my splendidly bad predictions.
Well, you heard it here first. Thanks. We had mentioned earlier about the anti-trolling bill that the federal government have produced in draft. Matt, how similar are the proposals to Section 5 of the English Act? It looked to me as though what the Australian draftsman had tried to do was to meld together both our statutory provision in Section 5 and the regulations made under it. And the result is a pretty turgid mess, isn't it?
Well, if you listen to the Prime Minister announce it, you would think it was entirely a homegrown innovation. But the truth is, it is modelled almost entirely, as you say, on Section 5 of the British Act and the regulations made under it. But it does do a couple of interesting things. It goes a bit further than the British position in some respects. And we had this decision of our High Court earlier this year in the Voller case, Fairfax and Voller, where the media was found to be a publisher, subject to the operation of defences, of third-party comments which were posted to stories that they put up on Facebook. And it prompted, for example, CNN to remove its stories from being visible in Australia via Facebook because they didn't want to take the risk of being liable for comments. So the proposed bill that the Prime Minister has announced would reverse that decision. So it's a boon for mainstream media and users of social media in respect of comments. But it deems the platforms, Twitter and Facebook and so on, to be publishers of everything that's posted on their services, whether they know of it or not. And it removes their right to rely on the traditional defence that they would seek to invoke innocent dissemination. But then, and the really interesting part is, it gives the social media platforms a safe harbour, in effect, as in England, if they identify the troll behind the posting of the comment, or if a court orders the disclosure of the or the unmasking of the troll behind the comment. But it is turgid. I'm always interested in how these things are in lived experience, and through you, Desmond, I could ask Andrew how this is working in practice in England and Wales. Is the mechanism so turgid that it's not invoked, or is it paradoxically having its, or surprisingly, having its desired effect?
Over to you, Andrew.
It's very rarely used in my experience. I think it is, as you rightly say, turgid, and for defendants' point of view, the e-commerce regulation is regarded as a more usable defence. But there's an online safety bill before Parliament, which does have some interesting provisions in it. And one debate here just worth mentioning on the question of anonymity online. There's an interesting suggestion that if you if you're Twitter or Facebook, you should have a real life registration, which you don't have to use. You can use an anonymous line for your posting, but you can then get a court order to reveal your real life registration. That's not in the bill at the moment, but it's part of the current debate.
That's the same here, and it just goes back two observations about our position. It's curious that the government's bill deals only with the question of defamation. So although it's called the trolling, I forget the precise title of it, but the anti-trolling bill, it doesn't deal with bullying or hate speech. It just deals with defamation. And the second observation, picking up on what Andrew said, is it doesn't grapple with the fact that some anonymous speech is incredibly valuable. You know, in the Me Too environment, or you know, criticism of repressive regimes and that kind of thing. There's no concession to that at all.
As we come towards the end of our time, I just wanted to ask about something we haven't yet touched on, which is the mode of trial and the right to trial by jury. Now, in England, under Section 11 of the 2013 Act, to all intents and purposes, the right to trial by jury has been abolished. Alan, when I started in practice, the media regarded trial by jury as the safeguard of their right to freedom of expression. I think you'd agree that that attitude has changed, but how has it come about?
Well, I've got personal cause to be very grateful for juries. There was one libel action in particular when we were sued by a number of police officers and had a judge who was so hostile to us. He retired shortly afterwards, but we were saved by a jury who found for us. And ever since then, I've always felt that the right to trial by jury is really important. In subsequent, we had two subsequent cases, one involving a corrupt MP and one involving Jonathan Aitken, who was then a cabinet minister, where they succeeded in getting rid of juries and hearing it by judge alone. And I mean, although we won both those cases, I had severe anxieties about the way those cases went. Why did that happen? I think it was to do with trying to minimize expense and trying to streamline actions. And it's true that in the good stroke bad old days, libel actions could go on for days, if not weeks. And I think it was felt that if you could try to hear some cases in front of judge alone, that you could reduce the length of cases. But it became misused, in my opinion. I mean, Aitken claimed that the issues before the court were so complicated that they couldn't be understood by a jury, and that it would be much simpler to have it in front of a judge. So I think it's a slippery slope, and I, for one, regret the fact that a defendant in particular cannot demand a case to be heard by jury.
Laura, would you be happier with your journalism in the hands of a judge or a jury? Which would you prefer?
Oh, I definitely prefer a jury, which is probably partly for all the reasons that Alan's talking about, and partly because anybody who sues in Australia now, basically, Matt can correct me on this, but you know, the preferred forum is the federal court, where you can have your case heard by a judge alone. And so there's a lot of criticism here about the fact that, you know, people find really complicated ways to find, to say that their case is relevant in the ACT, Canberra, or I don't know if this is related to those figures that you were quoting, Matt, on the number of cases in New South Wales, but yes, without a doubt, I'd feel much safer and happier in front of a jury than a judge.
Matt, just on the issues which juries now try in Australia, they're excluded from assessing damages now, aren't they?
That's right. So juries determine all the matters that the plaintiff has to prove, so publication and meaning and identification, and by and large they deal with defences, save for the odd question of law which is reserved for the judge, such as whether something's occurred on an occasion of qualified privilege at common law or whether a comment is in the public interest. But yeah, then very curiously, so the jury goes out and delivers its verdict in respect of all of those matters. And then if the verdict is for the plaintiff, the judge goes on to assess damages. The jury, of course, having heard all of the evidence, even when it's relevant only to damages, and quite often, for example, character evidence, which one always has a concern at the bar table, maybe poisoning the well of the jury's thinking in relation to matters it doesn't ultimately have to decide.
And there's now a ceiling on damages, isn't there, which is adjustable, is it?
Yeah, it's currently $432,500 for non-economic loss. It can be exceeded if there's aggravated damages, but we had this strange position, you alluded to the Geoffrey Rush case before, where the damages were obviously vastly in excess of the cap. That was because of a drafting problem in the 2005 provisions, which has been corrected from the 1st of July. So I think we're all pretty confident that the cap is now a cap.
All right, well, it's very nearly 7:29. And I noticed that Justice Peter Applegarth of the Queensland Supreme Court has been watching throughout all of this. I'm just going to allow you, Peter, the right of reply to the suggestion that Australian judges have been unreasonable about reasonableness.
Well, I think they have. I'm not defending the judiciary. I should disclose I'm a recovering Murdoch mouthpiece. Before I became a judge, I defended journalists. But judges have not always been that way. And if I could just briefly note that in 1975, in a celebrated case called Caldwell against IPEC that defended a very acerbic piece by Mungo McCallum, the High Court of Australia applied the Griffith Code and threw that case out of court. And so we have different judges in different generations having different views about reasonableness. And that decision came at the high point of Watergate, 1975, brilliant investigative journalism, National Times, ABC. And so I think you have to say that judges are influenced by their perception of what the media landscape is like at any one time. And so it's fortunate that back then, the High Court didn't inquire into the circumstances around the production of that piece, to take up Alan's point. There's no inquiry into what Mungo McCallum did or didn't do in phrasing what he phrased. And so for a brief time, we had, at least in the code states, a degree of protection, which we're now eventually getting in 2021 through amendments. And so in a kind of way, I think the judges, after all, are human. That has been established by some medical studies, and that they are influenced by the media landscape. In more recent times, it's hard not to, I suppose, be affected by the fact that a lot of the media is rubbish Murdoch tabloids, tabloid television, and as a result, judges, when they're called upon to decide questions of reasonableness, will be harsh. And the unfortunate consequence is if appellate courts take a dim view of what reasonableness is and have a restrictive view of reasonableness, as you've had ebbs and flows with Reynolds, and things seem to be good and then they're restricted, then they're opened up again. But I think we've, since 1975, come a long way, that the tabloid media got a break because the appellate court in Caldwell's case was influenced by high standards of journalism, and where we had investigative journalism well funded by Fairfax, ABC, and you couldn't help but be influenced by the success of Watergate. Now, unfortunately, the thing's gone the opposite direction, where reporters like Laura, Four Corners, vestiges of investigative journalism have to operate in a legal environment that's been shaped by laws responding to what most people would think is poor journalistic practices. And as a result, whether it's under our current laws of reasonableness or the ones that are coming through, courts do investigate minutely what reporters do and have these perfect vision of hindsight that you should have had a different headline, or you should have done another investigation, or you should have used different words. You should have made another inquiry. So if only we were back in 1975. Right.
Well, it's daylight behind Andrew Caldicott, and that reminds me that we've reached the end of our time. 7:30. I'm not sure it would be right to call it the witching hour, but at any rate, as I see Alan Robertson is back on my screen, and it only remains for me to thank you all very, very much for what I've found a fascinating discussion, and above all, a very educational one. And I wish we could all meet up soon, but heaven knows when that will be. Alan,
thank you.
Over to you.
Thank you, Desmond. I'll just say some brief further thank yous. So I thank again our distinguished panelists, Laura Tingle, Andrew Caldicott, QC, Matthew Collins, QC, and Alan Rusbridger. As I said at the beginning, at this busy time of year and this difficult time of day, although I'm glad to see the daylight has emerged even in December. I thank them for their insights and their incisive commentaries, and I thank Desmond Brown for his conduct as chair to produce really a seamless discussion of the various issues. And we've learned a good deal about both the formal and working aspects of the law of defamation, confidentiality, and privacy, touching freedom of expression. We've been brought up to date in relation to current cases and legislation, in relation to the social media anti-trolling bill 2021 in the Australian Federal Parliament, and we've benefited as well from the comparison between the position in the United Kingdom and the position in Australia in relation to freedom of expression. I thank Susan Jenkins for her essential technical assistance. I thank all of you in the audience for watching and listening, and I wish everybody a safe and enjoyable Christmas vacation. And I now close the event. Thank you all.
Thank you. It's very enjoyable.